My name is Michael Bowling. I'm here from the law firm of Bell and Roper, representing the appellant, the Marion County Sheriff, on this direct appeal of the final judgment entered after jury trial on damages alone on behalf of Mr. Avallone, the plaintiff, and his wife, Ms. Beauregard, on consortium claims. The judgment award in this case was substantial, with offsets, costs, claims of that nature. Totals approximately $2.5 million. Now, it's our position the jury award was grossly excessive in light of the plaintiff's numerous and severe pre-existing conditions and the rather minor additional problems this accident caused him. And frankly, the admission and the evidence, indisputable evidence, of an irrational and grossly excessive award of damages on the issue of future medical costs. It's our request the case be reversed.
They've conceded that the future medicals have to be remitted back to, what was it, 15,000 or something like that. I forgot the number.
They have.
But that's not even an issue anymore.
Well, Your Honor.
Your point being that it shows that this jury was out of control.
My point is very simple, Your Honor. It's the jury, and obviously plaintiff's counsel will correct me if I'm wrong. Plaintiff's counsel argued to the jury on future medicals, I'll quote you the specific language, that they should award future medical expenses based upon the evidence presented. All right. The judge also properly instructed the jury as to damages. Nevertheless, the only evidence in this case of future medical ranges from $11,000 to $15,000. Somehow, this jury came up with $150,000. Now,
were there any other future economic damages besides medical expenses to be considered by the jury? Not
that I'm aware of, Your Honor. Now, I must say I did not try this case, and I'm sure I'll be corrected if I'm wrong. So, our position, in very simple terms, is that, well, Mr. Avallone was disabled at the time of this accident. He had not worked for years. He had a severe heart condition. He was 59 years old at the time of the accident. The accident, we admitted liability on, the sheriff did, and it clearly caused Mr. Avallone some problems. I mean, he fractured his left heel, developed hammer toe, had 3 surgeries. These are all obviously damages attributable to accessible to the sheriff. However, the plaintiff then piled on. Mr. Avallone had severe pre-existing back arthritis, severe pre-existing right knee problems. The surgeries and treatment related to those conditions now come in as attributable to this accident.
Well, they do, right? I mean, and don't you take the plaintiff as you find them?
You take the plaintiff as you find them, but you also take the plaintiff, particularly with regard to the right knee, you take the plaintiff with understanding of what the condition is when he's found. And in Mr. Avallone's case, the right knee was already needed replacement. That's my understanding of the record. So the plaintiff's own treating physician says that regardless of this accident, he needs a full right knee replacement. So these things, you find them, you take them as you find them, but you do take them as you find them.
Well, let's see. On the knee replacement, apparently it was arthritic, and the doctor said there was a 100% probability he would have had to have the knee replacement even without the accident. But he did have more pain because of the accident. On the wrist, he had chronic SLAC. What is that?
I wish I could pronounce it for you, Your Honor, but it's some sort of, it's both an acute and chronic condition.
Slack wrist, predated the accident, but the accident aggravated it, caused pain, and eventually the wrist returned to its pre-accident base. His heel was primarily caused by the accident, and then he had post-traumatic stress disorder and whatever else. right?
Right, correct. And the treatment of the people.
What's the deal with his back? I've forgotten that.
Well, he had, Mr. Avalon had prior and subsequent back injuries. He had.
Yeah, but he said they had resolved before the accident. Right.
And then they happened again after the accident. The additional problems developed after the accident. Mr. Avalon's memory, if one goes through the record, one will note is far from the best.
I'm really not concerned about that because that's what the jury's for.
All right. So what we have, Your Honor, basically is a 60-year-old man who's not employed, so hasn't worked for years, whose activities basically include, prior to the accident, traveling with his wife, seeing Red Sox games, socializing with friends. Boating. All fine things, and I hope someday to be able to do all of those things myself. After the accident, Mr. Avalon does the same things. Now, I'm not going to argue that he does in the same frequency or extent, but he has the same behaviors. He travels. He doesn't do as much foreign travel. He boats with friends, but he needs some help to get his boat in and out of the slip. He saw 9 or 10 Red Sox games in 2009. I mean, he socializes with friends, goes down to a tavern. I mean, this is a man who was disabled before the accident occurred, and who is still engaging in the same behaviors, most of them, at a lesser rate as he did beforehand. Yet nonetheless, he's being awarded almost $2 million in damages.
Well, about $1.25 million in future non-economic.
Correct.
So we're
Yes.
looking at pain and suffering
Right.
and quality of life issues there.
Correct. Yes.
Why isn't the jury entitled to take all of those contradictory factors and conclude what it wants on that issue?
Well, the jury is obviously entitled to a great deal of discretion, but the jury's analysis, the jury's determination has to be based upon a review of the entire record.
Well, did you see the wife's testimony regarding the problems she had to go through in terms of pain management for him?
Yes.
I mean, it obviously had a big impact on the jury. She got a pretty good sizable award.
Yes, she
for
did.
future,
$445,000. I believe.
consortium, yeah.
But certainly the jury's got a great discretion, but what's happening here, what's being attempted here, is the plaintiff is trying to cut these into little pieces. The jury is rational and smart and it follows the court's instructions when it comes to future pain and suffering. But when it was related to future medicals, it made a mistake. And this mistake over here, this 10 times number, should not in any way be considered as relevant when considering whether or not the jury's determination on the other issues of damages.
You got any case law that suggests that because the jury screwed up one part of it, we have to presume they screwed up all of it?
Absolutely not. And frankly, Your Honor, there is case law out there to the contrary. I mean, one can screw up future medicals based upon something like they fail to reduce it to present value or something of that nature. But this is nothing like that. This is not some simple mathematical mistake or some error based upon the jury not understanding the instructions. This is an error of magnitude here, 10 times the amount of actual damages. A number basically pulled out from nowhere. Now,
What's our standard review on that?
Abuse of discretion.
And I mean, we have to give a lot of deference to the trial judge who saw the trial and listened to the witnesses and got the benefit of that, don't we?
Certainly. I mean, I'm not going to sit here and argue that abuse of discretion does not include a deference to the trial court and to the jury. But we need to, I think, review the entire record. We have a disabled man who is 60 years old, who gets a very large damages award. And thereafter, and in face of this very large damages award, there's also on the side, undisputed, an award of future medicals that is wrong by 10 times. So to simply assume that the jury did right on this side and wrong on this side without considering the entire record strikes me as unreasonable. Now, there's I'm not going to argue, let me be clear, there is, in my view, after reading many of these cases, no simple standard out there as to what's an excessive jury verdict.
Well, I'm looking at the final judgment, and I can't help but notice that there was a set-off of $304,000 paid by Harvard Pilgrim for medical expenses incurred by the plaintiff prior to the trial.
Correct.
I mean, that's a large number for prior medical expenses.
Well, that's a reduction of the jury verdict of 405 by 300. So the actual prior medicals are 80. Didn't see what? The jury verdict is reduced by that number. I think that's the collateral source set-off.
Well, it is, but I'm just saying that tells me that there was some serious injuries here. You got $304,000 paid by the carrier prior to this trial as past medical expenses. Why doesn't that support a judgment of this size?
I believe it's the other way around, Your Honor. I believe that the reduction of the jury verdict by $304,000 is the plaintiff boarded $405,000 in medical bills. Mm-hmm. The plaintiff's insurance company actually paid $80,000. That's the lien. As you guys just did to us in Brown, he said the collateral source reduces the amount of the damages. So that $305,000 is what they charged but did not pay. Okay. So, and this is because, as opposed to Brown, this is because this is a Medicare situation, I believe, as opposed to a regular straight up private insurance. I don't know, but in any event, it was offset. It was not an issue on appeal. So yes, certainly he has substantial injuries. I'm not going to say he doesn't have a substantial injury. He does have a heel fracture. Does require 3 surgeries. However, I think what we need to look at, what I hope the court will look at, is the pre-existing conditions, the plaintiff's ability to act and engage in conduct similar to what he engaged in before the accident, and then take that and look at it in light of the fact that the jury somehow came up with a number out of thin air, $150,000 for future meds, which simply doesn't exist. And that, to me, is suggestive of prejudice, of passion, something else. It's certainly not representative of an obedience to the court's instructions or an evaluation of the evidence. And I'd like to reserve the remainder of my time. Thank you, Your Honor.
We have about a little better than 7 minutes left.
Thanks.
Morning, may it please the court. Jessie Harrell with the law firm of Creed and Gowdy, and I'm here on behalf of Marianne Beauregard in her individual capacity and also as personal representative of the estate of Ronald Avalon. I wanted to pick up with a point that Judge Torpy made, that you're correct, that absolutely the defendant has to take the plaintiff as he finds him, and this is a classic case of an eggshell plaintiff. Did Mr. Avalon have degenerative changes in his spine prior to this accident? Yes, nobody disputes that. Were they painful? No. The defendant, when he causes the pain and thereby necessitates the treatment, he buys that. And it's exactly the same for the right knee. Would he have needed knee replacement surgery in the future? Yes, his doctor said that. Did the accident speed that up? Yes, it wasn't painful beforehand. And even the defendant's own doctor testified that because of the physical therapy that he had to engage in, where he had to hop on his right knee because his left heel was shattered, that anyone putting a significant amount of weight bearing on that right knee is going to experience difficulties. So there was testimony from their own CME doctor that this accident was what aggravated and sped up the need for the
I guess the primary argument of your opponent is that because the jury awarded 10 times a greater amount for future economic damages than that even the plaintiff admits was justifiable, that we should assume that there's some sort of splashover in the other areas of damages, and we should assume that they exaggerated those as well. How do you address that?
Your Honor, that is contrary to the law, and I provided the court with supplemental authority. Unfortunately, I didn't get it filed until this morning, but I did fax it to counsel yesterday. There's a Florida Supreme Court case of ITT Hartford versus Owens, which is at 816, 572. And that case explains that you look, when you have an itemized damage form, you look at each item of damages individually. And in that case, the court said the only question remaining is whether the defendant is entitled to a new trial in which all damages issues will be considered, or in which the only issue is the future medical damages. And the court said that the plaintiff's future medical damages constitute a discrete item of recovery separate from other damages, and because you had the special verdict forms, you're only going to retry on that narrow item of damages. And it's the same way that cases that we did cite, like subaqueous services out of the first DCA, and Astrogaric was a second DCA case. Those both said you had, in both of those cases, the jury gave larger future economic damages, and the court remanded, ordered retrial on only those items as opposed to the non-economic damages. And the reason is that it doesn't go to...
Do you want a retrial on the future economic damages?
No. No. And that's why we agreed to the remittitor, and I think that a retrial would be inappropriate because we have agreed to the remittitor.
When did you agree?
In this appeal.
In this appeal?
Yes, sure.
Not when it was asked for?
That's correct. The difference as to why the future economic damages are entitled to remittitor, though, is, as you know, there's 5 factors under the statute, and passion and prejudice is only one of them. The other factors look at whether the jury ignored the evidence or misconceived the merits, if they arrived at the verdict by speculation and conjecture. And what you have here is a jury who heard a great need for future medical care. What they didn't hear was the cost. And so they sat back and this wasn't a case of passion or prejudice. They heard that if he lives to a certain age, he's going to need another knee replacement. They heard that if his wrist continues to be painful, that he's going to need a fusion. They heard that he's going to need continuing physical therapy and medications. They just didn't hear how much that was going to cost.
And we know this how?
It's all in the record, Your Honor.
We know what the jury was thinking?
Oh, no. We don't know what the jury was thinking, and it's not our place to second guess what the jury was thinking.
What were you just doing?
I
Second guessing what the jury was doing?
I apologize. That was not my intention.
Did they hear testimony about? Did they see pictures of the wreck, the accident?
They did, Your Honor.
Yeah, how bad an accident was? I mean, how much damage was done to the car?
Your Honor, I believe it was considerable, although I don't recall offhand. I remember that there was testimony that the airbags deployed, that Mr. Avalon actually thought that the smoke was a fire and begged the sheriff's deputy to shoot him and kill him so he wouldn't burn to death. It was a very traumatic accident that, as you know from the record, fractured his heel, and he wasn't even able to have surgery for over a month because the swelling had to go back down before they could even attempt to put his heel back together. So there was, my point is that there was substantial evidence in the record to support this jury verdict, and we don't need to jump to the conclusion that the future economic damages were the result of passion and prejudice when there's other factors under the remittitor statute that make remittitor appropriate for bases other than passion and prejudice.
Well, I think that's pretty much it.
I think it is, unless this court has any more questions for me.
Thank you very much.
All right, thank you.
I'll be brief, Your Honor. I encourage the court to review the ITT Hartford case. It's cited as supplemental authority. It basically stands for the proposition that that you can, in fact, reverse just on economic damages. I've not made any claim to the contrary. The case, however,
let me ask you something.
Sure.
If we should decide that future medicals were exaggerated and should have been no more than $15,000, would you rather have a new trial on future medicals, or would you prefer just simply for us to order a remittitor of that, order the trial court to order a remittitor?
were miniature, Your Honor. I'll be frank with you. I'm not going to retry it on that, especially in light of the plaintiff's dying. It would be complicated, to say the least. So, in light of that, Your Honor, clearly the court understands the issues. If there's any questions?
Thank you very much.
Thank you. Safe trip home.
All right.